Good morning, Your Honor. Case number IT 0482I, the prosecutor versus Johan Tarčulovski.
I thank you. Mr. Tarčulovski. Mr. Tarčulovski. Please, Usher, make sure that he is on the right channel. Before I proceed any further, I want to make sure that you are receiving interpretation in your own language.
No.
No. So that's problem number one. 8 o'clock on a Monday morning. Are you receiving interpretation now?
To je na albanski. It's not Macedonian.
I'm receiving the Albanian language and not Macedonian.
To check. Are you receiving interpretation now? You are receiving interpretation now. All right. For the time being, that's the most important part. Most important thing that I wanted to make sure of. If at any time you are not receiving interpretation, please draw my attention immediately. Okay, thank you. You may sit down for the time being. Yes, appearances for the prosecution.
Good morning, Your Honor. Kenneth Scott for the prosecution. With me this morning is Mr. William Smith and our case manager, Mr. Hassan Yunus.
Okay, I thank you and good morning to you and your team. Mr. Tarčulovski, I take it that for the purpose of this initial appearance, you have decided or you have asked to represent yourself. In other words, you have chosen not to be assisted by counsel. Am I correct?
Your Honor, I didn't have an opportunity for my attorney to be present here.
But that's different. Did you ask the registrar to provide you with counsel, even if it was only for the purpose of this initial appearance?
I asked strictly for it to be my attorney, if that is possible.
We need to verify this. But for the time being, did you choose to represent yourself during today's initial appearance?
I would like to use my legal possibility. I would like to use the legal time frame of 30 days to make my statement.
I don't think that was the question that I put to you. I was informed that you asked to represent yourself today during this initial appearance. In other words, that this is your choice only for today's initial appearance. Did I get the right information, the correct information, or is it the wrong information?
Your Honor, I asked my initial appearance to be postponed until after my attorney arrives.
Do that. I can't postpone the initial appearance for the reason that you have mentioned. The practice here is that if it is not possible at all for the registrar to approve or to approve and appoint and designate the attorney, the counsel of your choice, then for the purpose of the initial appearance, another counsel is appointed. He will serve you for the purpose of the initial appearance, and then he or she will disappear from the scene. So you create a little bit of a difficulty for me this morning, because I need a straightforward answer from you. There is no point in waiting necessarily for the initial appearance until you have your own lawyer, the one you have chosen, approved by this tribunal, because at the end of the day he may not be approved. I'm not saying that he will not, but I don't know who he is, and I have got nothing to do with his would-be appointment. Short of that, there are two options. Either we proceed today with you representing yourself, if that is your choice, or else I stop here and I will have the initial appearance tomorrow or the day after, and the registrar will appoint for you another lawyer, not the lawyer that you want from Macedonia or from wherever, but a lawyer who will act as duty counsel and who will appear and represent you only for the purpose of the initial appearance. So there are these two alternatives, and you need to tell me which one you prefer, if at all, because if you remain silent, then of course I will have to take a decision on my own.
I would like to represent myself.
I thank you, and I can also assure you, Mr. Tarčulovski, that that being the case, I will make sure that all your legal rights arising out of the statute and also our rules, especially as they relate to today's initial appearance, will be strictly observed and respected. I will do that myself. Before we proceed, I am also informed actually that you did sign a letter or a declaration which you handed to the authorities of this tribunal, to the registrar, stating for all intents and purposes that you had decided already to represent yourself at this initial appearance. Is that correct?
I couldn't hear him, but I suppose he said yes.
All right. Before I ask you to sit down, Mr. Tarčulovski, there is an important right that you enjoy, not only today, but throughout all the proceedings that will follow until the closing of the end of the trial, and any other proceedings that may follow. And this right is fundamental to due process and a fair trial. And that is your right to remain silent, your right not to incriminate yourself, your right not to be forced to answer any questions. I also, however, have to advise you that should you not opt to remain silent, whatever you say will go into the record, and as such could constitute evidence. Did you understand me? Okay, you.
Yes.
I will proceed first with giving a summary of the indictment. This is particularly, I consider it particularly important, especially in those cases where the accused chooses not to have the indictment read out, so that members in the public gallery, and I see very few, but also the public in general, that may be following these proceedings from their homes or elsewhere, would be able to know precisely what the case is all about. And this is also necessary according to me, because this tribunal is tasked with also looking after the interests of the victims. The proceedings, today's proceedings, because of the limitations that we have, are being interpreted in Macedonian, which is the accused language, but also in Albanian, part of course from the English and French, also in Albanian, because that in the assessment of myself as the pretrial judge for the purpose of this initial appearance is the language of the victims. You, Mr. Tarčulovski, along with another co-accused, Boškoski, you were included, and you are included in an indictment with case number IT 0482, which was signed on the 22nd of December of 2004. This indictment was confirmed by my colleague, His Excellency Judge Patrick Robinson, on the 9th of March of this year, and it was made public by a decision of the same judge on the 15th of March of this year. I am informed that you arrived at the seat of this tribunal last week, to be exact, on the 16th of March. According to the indictment, Mr. Tarčulovski, you were born on the 17th of November 1974 in Skopje, in the Republic of Macedonia, the Socialist Federal Republic of Yugoslavia. In 2001, according to the indictment, you were a police officer acting as escort inspector to the President's security unit. Your duties included providing personal security for the President of the former Yugoslav Republic of Macedonia. The prosecutor also alleges that you were a member of the internal Macedonian Revolutionary Organization, to wit, the Democratic Party for Macedonian National Unity. The prosecution alleges that a state of armed conflict existed at all times relevant to the indictment on the territory of the former Republic of Macedonia. In this regard, I would like to draw the prosecution's attention that although this is stated in preeminently in one part of the indictment, at the same time and in the same breath, you were alleging that the conflict ended with the Ohrid peace accords on the 13th of August. But anyway, take it for whatever it's worth. According to the indictment, you are charged with individual criminal responsibility pursuant to sub-article 1 of Article 7 of the Tribunal's statute. I'll try to explain very briefly how the prosecution is attributing to you individual criminal responsibility. In other words, in what form? The prosecution is alleging that you committed, ordered, planned, and instigated the crimes charged in the indictment, to which I will come very shortly. The indictment states that you aided and abetted, in addition, the crimes charged in the indictment. By using the word committing, the prosecution is not alleging that you physically perpetrated any of the crimes charged. Rather, committing is being used in the indictment as participation in a joint criminal enterprise. What is this joint criminal enterprise in terms of the indictment? The indictment is alleging that you were a member, as I have just stated, of a joint criminal enterprise which came into existence no earlier than Friday, the 10th of August 2001, and continued up to and including Sunday, the 12th of August 2001. According to the indictment, the object of this joint criminal enterprise was to direct an unlawful attack on civilians and civilian objects, which was not in any way justified by military necessity. And the attack took place on the village of Ljuboten, a predominantly ethnic Albanian village, about 12 kilometers distant from Skopje, which is the capital of the former Yugoslav Republic of Macedonia. You are basically charged with 3 counts of violations of the laws or customs of war pursuant to Article 3 of the statute, which is in turn based on the Geneva Conventions. One is murder, second is wanton destruction of cities, towns or villages, and third but not least, cruel treatment. I will go through these one by one. In count 1, you are being charged with murder. According to the indictment, during the attack on Ljuboten, which took place on Sunday, the 12th of August 2001, members of a police unit commanded by you first entered the yard of Rami Yusufi's house and shot him, as a result of which he died 2 hours later. Afterwards, you and members of the police unit arrived at the site of 2 houses where unarmed men, women and children had sought refuge from the attack of the police and the army. The police ordered the men out of the basement and forced 13 of them to lie on the grounds, where they were all beaten up repeatedly and severely. A certain Suleiman Bayrami attempted to escape, and he was shot dead. Another man, Atullah Aili, died the following day as a result of those beatings, and further beatings received whilst he and the other men were being transported from Ljuboten to Mirkovci police station. The indictment further alleges that after these 2 incidents, the police ordered 10 of the 12 remaining men to walk towards the neighboring Macedonian village of Ljubanci. The remaining 2 men, both elderly, were ordered to leave the area by the police, and as these 2 men walked away, the police fired at them, killing Muharrem Ramadani, a 65-year-old ethnic Albanian. The indictment further alleges that later on in the day, you, Mr. Tarčulovski, and members of the police unit under your command moved to a house where 5 unarmed men had taken refuge. After calling out for the owner of the house, the police unit opened fire on it and set fire to it using gasoline. When the men inside the house tried to escape, the police unit shot at them, forcing them to run towards the mountain behind the house. 3 ethnic Albanians on this occasion, namely Shelal Bayrami, Bayram Yashari, and Kadri Ashari were shot dead. That's as regards the first count. In the second count, the prosecution is bringing against you a charge of wanton destruction of cities, towns, or villages, again in violation of Article 3 of our statute. According to the indictment, during the attacks on Lyubotin village on Sunday the 12th of August 2001, Johan Tarčulovski and members of the police unit commanded by him walked through Lyubotin and intentionally set alight at least 14 houses. In addition to setting fire to houses, the police also damaged houses by use of hand grenades and small arms. As a result of these acts, 14 houses were seriously damaged or destroyed. And this is the factual background to count 2, which contains a charge of wanton destruction of cities, towns, and villages. In count 3, you are being charged with cruel treatment, again as a violation of Article 3 of the statute of this tribunal. The indictment alleges that between the 12th of August and the 21st of August 2001, during and after ground attacks on Lyubotin, you and members of your police unit detained over 100 ethnic Albanian male residents of the village at various locations and intentionally inflicted severe pain or suffering to them by beatings, humiliation, harassment, and psychological abuse. These residents were cruelly treated both within Lyubotin, and the indictment specifies at 2 police checkpoints nearby, as well as outside the village, and namely at 5 police stations in Shair municipality and Skopje city, as well as at the Skopje court and hospital. The prosecution alleges that cruel treatment first occurred both outside the village, where a group of 13 residents was beaten at Adem Ametovsky's house, and outside the Lyubotin, where a further group of 90 male residents was detained at a police checkpoint a few kilometers from the village. At least half of these men were physically and psychologically abused. Following these initial beatings, both groups were moved to different police stations and then, in some cases, to the Skopje court too, and to the Skopje city hospital. The prosecution alleges that the detention and beatings of these arrested men were organized, systematic, and pervasive. Most of the detainees were beaten repetitively at successive locations. For example, and this is always according to the indictment, between the 12th and the 15th of August 2001, the prosecution alleges that at least 7 men were beaten at 5 different locations. At least 25 men were beaten at 4 different locations. At least 44 men were beaten at 3 different locations. And at least 12 men were beaten at 2 locations, and at least 2 men were beaten at 1 location. This is the background information on the indictment. The president of this tribunal, Professor Theodore Meron, by order dated the 16th of March 2001, assigned this case to Trial Chamber 2, of which I am the presiding judge. consequently, the day after, on the 17th of March, as presiding judge of Trial Chamber 2, I designated myself as to act as pre-trial judge for the purpose of today's initial appearance. I am now going to proceed to a strictly procedural part of this initial appearance, which I am tasked to do pursuant to Rule 62 of the Rules of Evidence, Procedure and Evidence of this Tribunal. And then, having done this, I will proceed to ask you whether you would like to enter a plea today, or whether you wish to postpone your decision to later. Mr. Tarčulovski, could you please stand up? I am tasked, have the responsibility to raise with you, first and foremost, issues relating to legal representation. I know that this was briefly touched upon in the earlier stages of today's initial appearance, and I also heard you state that you already have in mind a particular lawyer that you would like to have as your counsel for the proceedings that will follow. And I take it that you have already made representations to that effect with the registrar of this tribunal. Is that correct?
Yes, it is correct.
I wish to inform you, Mr. Tarčulovski, that according to our rules of procedure and evidence, particularly to Rule 45A, whenever the interests of justice so require, so demand, counsel shall be assigned to suspects or accused who lack the means to remunerate such counsel. Such assignments shall be treated in accordance with the procedure established in a directive set out by the registrar and approved by the permanent judges. In addition, Rule 45F provides that a suspect or an accused electing to conduct his or her own defense shall so notify the registrar in writing at the first opportunity. So let me briefly explain what the situation, what the position is. You have a right to represent yourself. You have a right to defend yourself, and no one can question that right or deny you that right. So if, apart from today, you decide to defend yourself, that right will be respected. You also have a right to be assisted by counsel of your own choosing. But this right is not an absolute one. It is qualified. It is a relative right. It is qualified by the rules of this tribunal, which establish certain criteria which need to be followed and satisfied before counsel of your own choice is designated and approved by the registrar of this tribunal. It's not something that the trial chamber gets involved in. It's something which falls within the discretion of the registrar. There are certain requirements that the lawyer that you indicate must fulfill. If those requirements are not fulfilled, then the registrar can deny you the right to be represented by that particular counsel. But this is something that you will, of course, I'm sure, and your designated lawyer deal with the registrar directly. And who will pay for the counsel that is appointed for you ultimately depends on your means. We have a system of legal aid which is operative in this tribunal. but system of legal aid depends on your means, basically. And again, it will be the registrar who will make the necessary assessment before a decision is taken. Did you understand what I told you? Right. And again, I repeat just for the record that today you are unassisted because you have so chosen after what I explained to you earlier on. Now, Mr. Tarčulovski, I'm going to ask you some questions. Could you give me your full name for the record, please?
Johan Tarčulovski.
Johan Tarčulovski.
To ask you a question, if you prefer not to answer it, you of course are free not to answer it, because it may have a relevance later on, particularly if you have a nickname. Do you have a nickname that you are referred to, by which you are referred to? Okay.
I didn't hear him. Could you please ask him to speak up, because we seldom hear what he says. This is an interpreter's comment.
Okay. The interpreters are telling me, because what you are saying is being translated to me in English, and the interpreters are not hearing what you are saying. So if you could raise your voice a little bit, it would help. Could you give me, please, your date of birth?
17th of November 1974.
Yes, and where were you born, your place of birth?
Skopje.
What is your nationality?
Macedonian.
Now I suggest we go into private session, because I'm going to ask the witness for his home address, and I don't think that is necessary for the general public to know. We are in open session now. Are the members of your family informed of your transfer here to The Hague and your state of detention here in Scheveningen in the UN's detention unit?
Yes.
Would you like me to inform any member of your family that might not be aware of your situation?
No.
Is your embassy here in The Hague informed of your transfer? And has it been in contact with you?
I called them.
Would you like me to inform or contact the members of your embassy here on your behalf?
No.
Please do sit down, Mr. Tarčulovski. As I tried to explain earlier on, you enjoy a number of rights which trigger on from the very moment that you came under the custody of this tribunal. These rights are enshrined in our statute, and they are also reflected in several places in our rules of evidence and procedure. I am going to ask Madam Registrar to read out to you Articles 20 and 21 of our statute, because they embody the totality of the rights that are spelled out in the statute itself, and which will regulate and govern the proceedings from now onwards. I want to make sure that you are fully aware of these rights, and that is the reason why I'm asking Madam Registrar to read them out to you. Madam Registrar, could you be kind enough to read out slowly Articles 20 and 21 of our statute, please?
Article 20. Commencement and conduct of trial proceedings. 1. The trial chambers shall ensure that a trial is fair and expeditious, and that proceedings are conducted in accordance with the rules and procedure of evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. The hearing shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21. Rights of the accused. All persons shall be equal before the International Tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. 3. The accused shall be presumed innocent until proved guilty, according to the provisions of the present statute. 4. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense, and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence, and to defend himself in person or through legal assistance of his own choosing, to be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interest of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G. Not to be compelled to testify against himself or to confess guilt.
I thank you, Madam Registrar. And now we come to perhaps the basic part of today's proceedings. First of all, Mr. Tarčulovski, have you received you've heard Madame Registrar read out Articles 20 and 21, spelling out the rights to which you are entitled. Do you understand the importance of these rights?
Da.
Yes.
Is there any particular part from these two articles that you would like me to explain to you? And I'm saying this, usually I don't do this when there is a lawyer present. But I take it, do you have a legal background yourself? No.
No.
Is there anything you would like me to explain to you?
No.
There isn't anything.
I want to make sure that you have understood the importance of these rights and the importance that the statute itself gives to these rights. Were you served with a copy of the indictment?
Da.
Yes.
Was it served on you in your own language?
Da.
Yes.
Did you read it?
Da.
Yes.
Did you understand its contents and what it charges you with, which crimes it charges you with?
Da.
Yes.
Do you require me to explain anything from that indictment to you?
No.
Now, Mr. Tarčulovski, our rules give you the right to have this indictment to be read out in full in public. You can also waive that right, and many a time this right is waived. But it all depends on you. If you want us to read out the indictment in full, we will do so. If you waive that right, then the brief summary that I gave earlier on will suffice. Do you have a choice?
Dovoljno.
It is sufficient.
In other words, you waive the right to have the indictment read out in full. All right. That are brought against you in the indictment and which I referred to earlier. There are three possibilities. You can opt to enter a plea today.
That's good.
Yes.
Pardon me, Your Honor, excuse me. I wasn't meaning to interrupt, but I didn't know how quickly we might get to talking to him about entering a plea. Just for clarification, point of clarification, so there's no confusion. In connection with count 3, the cruel treatment charge, it's explained in paragraph 42 of the indictment, Your Honor, that as to that, Mr. Tarčulovski himself is only charged with the acts which are specified in paragraphs 31 and 32. That is stated in the indictment, and Mr. Tarčulovski has indicated he's read the indictment in his own language in full.
Yeah.
Nonetheless, I just wanted to be clear, especially for purposes of taking a plea, that he understands that as to the cruel treatment count 3, he is specifically charged with those allegations stated in paragraphs 31 and 32.
Yes, and that is Adam Ametovsky's house and Bracha's house. Yes, are you, there are these three thank you. There are three possibilities. Possibility number one is that you enter a plea today. Possibility number two is that you don't. You choose not to enter a plea today, and you reserve your right to enter a plea later. Possibility number three is to remain completely silent today and later. If you choose not to enter a plea today, our rules specify that there is a time limit of 30 days within which you can enter a plea. If you don't enter a plea within those 30 days, then the trial chamber or the pretrial judge will enter a plea on your behalf, which will be a plea of not guilty. If you remain silent now or later, again the pretrial judge will enter a plea on your behalf, and that will be a plea of not guilty. Have you thought about what you would like to do today, whether you are prepared to enter a plea today or whether you would like to postpone your decision?
I would like to postpone my decision for within 30 days.
And for the record, Registrar, please note that the accused has stated that he will enter a plea within the 30-day period that is allowed under Rule 62A of the Rules of Evidence and Procedure. So the position is that within these 30 days, or towards the end of the 30 days, there will be a continuation of today's initial appearance. And you will then enter a plea, which could be one of guilty or one of not guilty, or you can opt to remain silent. But there will be a continuation of today's initial appearance towards the end of the 30-day period. And of course you will be informed, and if by that time you have a lawyer assigned to you, he will also be informed. So there are some, you may sit down, Mr. Tarčulovski. There are some points that I need to point out to you. We have a special rule, Rule 63, which provides that any questioning of you by the prosecution, including after the initial appearance, shall not proceed without the presence of counsel, unless the accused has voluntarily and expressly agreed to proceed without counsel present. If the accused subsequently expresses a desire to have counsel, questioning shall therefore cease and shall only resume when the accused counsel is present. Furthermore, under the same rule, paragraph B, the questioning, including any waiver of the right to counsel, shall be audio recorded or video recorded in accordance with our procedure, established procedure. And in addition, the prosecuting officer or the investigator shall, at the beginning of the questioning, give you a caution in accordance with Rule 42, namely that it will caution you that you have a right to remain silent, and that any statement or anything that you may say will be recorded and may be used in evidence. Now, very soon after this initial appearance, I will, first of all, did you understand the importance of this provision from our rules that I have just mentioned to you? Okay.
Yes.
In addition, in terms of Rule 65 bis A, I will appoint a pretrial judge very soon after today's initial appearance, and I will task him or her with presiding over the continued initial appearance, and also to act as pre-trial judge until we come to the trial stage. The pre-trial judge will convene status conferences within periods of 120 days. The first one will be from the end of the initial appearance, and subsequently within 120 days from each previous status conference. I'm sure that the pre-trial judge that I will appoint will explain to you the next time you appear before this tribunal what this is all about. But for the record, I can explain to you very briefly that the purpose of a status conference is twofold. First of all, it gives an opportunity to the parties, together with the pre-trial judge, to organize whatever needs to be organized for an expeditious preparation for trial. And secondly, it also gives the opportunity to the pre-trial judge to see you in person and ensure that you are being treated well, and to also hear what you have to say should you have any complaints or any particular requests. You will, of course, be informed in due course of the dates of these status conferences. I will also, on the assumption that you will enter a plea later on within the 30 days, I will instruct the registrar to follow the proceedings to see if it's the case of fixing an early date for trial as early as possible. That's unless you enter a guilty plea, in which case there will be special proceedings. For the time being, Mr. Tarčulovski, pursuant to an order which I signed on the 17th of March, you are to remain in custody in the detention unit in Scheveningen. But our rules, particularly in Rule 65, envisage the possibility that, or right which you have to file an application for provisional release. Of course, if you have a defense counsel assisting you, he will be able to advise you, or she would be able to advise you on this. However, I want to make it clear that the fact that you do not yet have counsel assigned to you should not be an obstacle should you desire to exercise your right under Rule 65. That is a right to ask for provisional release. I also want to make it clear that having a right to ask for provisional release does not mean that automatically, once that right is exercised, the trial chamber has to accede to that request. We are still in the very early stages of these proceedings, and it's very rare that such requests are acceded to at this early stage. However, you have a right to file such an application, and if the assignment of counsel takes a long time and you would like to file such an application, I am sure that you will receive all the assistance that you required, either from the office of the registrar itself or from the commandant of the detention unit, and you can formulate such an application yourself in writing, in whichever way you deem fit and proper. Mr. Scott, I need barely remind you, of course, of your responsibilities under Rule 66A1 of the rules, and namely that you have 30 days of the initial appearance of the accused to make available to defense counsel in a language which the accused understands, all the supporting material which accompanied the indictment when confirmation was sought. Of course, there are caveats because we don't yet have defense counsel. There is no statement from the accused that he would like to receive them himself, and also the initial appearance hasn't come to an end and will not come to an end today. But I'm sure I need not explain these to you. Please, Mr. Scott, if you have anything to state in this regard.
Thank you, Your Honor. We appreciate that. We are, of course, very mindful of our obligations. We don't anticipate any problems. We do, of course, anticipate, as in every case, to file a motion for general protective measures prior to any actual disclosure, and I think that's basically, as you know, standard practice. The only possible delay that could involve, as to some materials, would be, unfortunately, of course, the translation issue, but that's underway. But we would anticipate meeting their obligations. Thank you.
Okay. I thank you. And then, Mr. Tarčulovski, I'll try and explain this to you. But again, if you have assistance of counsel, it will be easier. We have a special rule dealing with preliminary pleas, and that is Rule 72A. This rule establishes or fixes a time limit of 30 days for you to file any preliminary motions once you have received all the supporting material in accordance with the article that I pointed out to Mr. Scott. So I hope that you will have counsel designated pretty soon, and that you will then be able to discuss with him if it's the case of filing any preliminary motions. If you have problems with this and later on, especially if there are problems in the designation of counsel of your own choice, and you have problems, you can seek the assistance from the registrar, and also you can seek the assistance of the pretrial judge that will be looking after the pretrial stage. Did I make myself clear? Okay, thank you. Yes, Mr. Scott, is there anything that prosecution would like to raise? Of course, the counts, because I appreciate you pointing out count 3 and count, there are other things that come out when we come to the counts proper. But I would have come to those, of course, if I had a message of he was going to plead guilty. But that will be dealt with later on by my calling. It will be Judge Azer who will be appointed as pre-trial judge, but also to continue with the initial appearance. In other words, I will task him with that, and he will deal with that. In the meantime, is there any other matter that you would like to raise?
No, Your Honor, thank you very much. We just wanted that one point to be clear, but we anticipated also that the actual entry of a plea would be postponed. Thank you.
Okay, I thank you. Mr. Tarčulovski, is there anything any matter that you would like to raise at this stage?
No.
But before we adjourn, there is one thing that I want to make sure of. And you arrived here in The Hague. Did you surrender voluntarily?
Was detained.
Detained. Since the moment of your detention. Have you been treated well?
Yes.
And upon your arrival here in The Hague, you're being taken into custody in state of detention in the detention unit. Have you been treated well there?
Yes.
Do you have any special requests or complaints in regard to your state of detention? which could also touch on health matters if you have any. If you do, we will go into private session and we will discuss those in private session.
No, I don't have.
So I think you may sit down, and this brings to an end the first stage of the initial appearance, which will be continued towards the end of the 30-day period, and which will be presided over by another judge. I thank you all, and we stand adjourned.
All rise, veuillez vous lever.